Hi, welcome back to Your Future, Your Finances. Again, we're talking with Neil Tyra of the Tyra Law Firm. Welcome back.
Thank you very much.
As we went into the break, we were talking about legal documents and tools that you as an attorney would use. What are some of those?
Well, we mentioned briefly the power of attorney and the Advanced Healthcare Directive. Now, the two main ones for most people that after that would be a last will and testament, or sometimes just referred to as a will. And for most people, a will is sufficient. What a will does is specify somebody to act as your executor when you pass, and that person then distributes your assets in accordance with the wishes that you've stated in the will. And so for most people, as I said, that's all they need. But for some people, there may be a reason to have something called a trust. And a trust has its origins back in feudal times when knights went off to fight. They would entrust their property to somebody, a trustee, to take care of while they were gone. And if they didn't come back from the crusade, that trustee was charged with the responsibility of distributing their property in accordance with the owner's wishes. A trust is exactly that. It's a document that you set up into which you put all of your treasures, if you will, your assets, with instructions on what to do with them when you pass. And for some people, a trust, and there are many, many types of trusts, the most common one is a revocable living trust. For some people, that's the most flexible and the best choice for estate planning. For one thing, being revocable, you can change it, you can modify it, you can add, you can delete. And so it's a very flexible tool.
So you said for most people a will, or for some people a will, and then others a trust plus a will. What would be some of the differentiators that would help you advise them one way or another?
Well, one of the things is that when you have a will, by definition, you go through the probate process because your executor would then, upon your death, take the death certificate and the will to the court and say, I'm the executor, and I need to get the authority to do what this will says. So that process is public, and it's sometimes a little bit time-consuming, and in some ways it can be expensive. A trust skips that part. A trust names a trustee or co-trustees in the event that one can't serve in that capacity. It doesn't go through probate. It's not administered by the court. So you simply take the trust document to whomever owns the assets, and what you really do is you have the trust itself, which is a legal entity created by the trust document. The trust actually owns those assets. And so the trust document specifies where they're to go, what's to be done with them, and it does not have to go through the court. So it's more private, for one. It's quicker. It doesn't have the delay that's built in having to go through the probate process. And it also gives you some additional flexibility. So if the person was someone who had a person in their family with special needs or had children to whom they didn't want to give money to right away, they maybe wanted to space it out over time, a trust would be the right tool for them.
So what happens if you don't have any of these documents? I think you mentioned in a talk, I heard you, some percentage of people don't have any documents.
Yeah, it's stunning that only 30% of the people who pass have any estate planning.
Wow.
30 to 40%. So 6 or 7 out of 10 people pass without any estate planning in place. So there's good news and bad news about that. The good news is that the state of Maryland, and every jurisdiction, frankly, has their own estate plan, and it's built into the statutes that govern the transfer of wealth. So that's the good news. The assets will get distributed. The bad news is it may not be the way you want them to be distributed. So it's a process that meets the most common scenario, and that scenario may not be, the one specific for your family needs.
Yeah. So you have these documents because it's recommended that you do it. So now what do you do with them?
Well, the first thing, the very important thing to do is, one, make sure they're stored safely and securely. I like to recommend to folks that they actually store them in the courthouse. The court offers the process of filing those documents in advance, which makes sense because the executor or will have to go to the court anyway to present the will. So if it's already there, it's stored and maintained. Either that or you put it in a safe deposit box or something really secure. But you need to make sure that somebody knows where it is and how they can get to it after you're gone. Because if you haven't told anybody, they're never going to find a will.
Yeah.
So that's the primary thing to do.
And then while you're living, you want to maintain these documents. Things change, families change. How often do you typically advise your clients to update them?
Again, this is a really important point that people overlook frequently. We'd like to, the older you get, the more frequently the document should be reviewed, because things happen in your life that might change your distribution. So younger clients, we say every 5 years or so. Older clients every couple of years, or whenever anything of significance, loss of a spouse, loss of a child, addition of a spouse, addition of a child, when something major like that happens.
Okay, great. Very helpful stuff to the audience. Is there a website you want to give out?
Sure. You're welcome to come and visit the law firm's website at www.tyralawfirm.com.
TyraLawFirm.com. All right. Thanks for coming on the show.
Ryan, thanks so much for having me.
Sure. You've been watching Your Future, Your Finances. If you have any questions or comments for the show, email questions@yfyfshow.com. We thank you for watching, and have a great day.